Hello everyone and welcome to another module of Economics and Law Part 1. Today we are going to discuss the economic representation of fault and efficient precaution. Let us start by understanding that tort law deals with civil wrongs that result in harm to a person, property or reputation. Now, unlike criminal law, which focuses on punishing offenders for violations against the state, tort law aims to compensate victims for losses suffered due to another party's wrongful conduct. So, the concept of fault is central to determining liability in tort cases. To successfully claim compensation, a plaintiff who is the injured party must prove the defendant, who is the allegedly responsible party, has breached a duty of care, causing the plaintiff's harm. This requires establishing four crucial elements. First is the duty of care, which states that as a general rule, every person has a legal duty to act with a reasonable standard of care to avoid causing harm. This duty can arise due to a plethora of factors such as the nature of relationship between the parties or the situation. For example, a driver has a duty to operate their vehicle with reasonable care to avoid injuring pedestrians. Second is the breach of duty, which refers to a situation wherein a person has failed to exercise their duty of care through acts or omission. Third is causation. The third factor is causation, which stipulates that the plaintiff's injury must directly result from the defendant's breach of duty, implying a close connection between the harm and the breach. In other words, the harm would not have occurred but for the breach of duty by the injurer or defendant. And fourth are the damages, where the victim must suffer some actual legal harm as a result of the breach of duty. The court might find the injurer liable for the damages if all these elements can be satisfied. Determination of liability is one of the key functions of the law of torts. The economic representation of fault goes a step further. It aims at recognizing the impact of economic sanctions and cost on influencing behavior and promoting efficient risk management within the society. Traditional tort law focuses on assigning blame and compensating victims, but economic analysis adds a powerful dimension. By considering how financial consequences influence behavior, economic analysis in tort creates a system that goes beyond simply assigning fault. It becomes a tool for deterring risky behavior. Holding at fault parties financially responsible for damages discourages them from taking unnecessary risks in the first place. This economic perspective paves the way for a deeper understanding of fault under tort law, where it's not just about blameworthiness but also about the economic incentives that shape behavior and ultimately influence the safety within the society. This concept forms the core of the economic representation of fault under tort law. Let us now learn about the economic representation of fault. The economic analysis of law means the juxtaposition of economic models to evaluate legal rules. It is rooted in the idea that law affects the behavior of an individual and various doctrines of common law, reflect an underlying economic logic, usually in terms of financial consideration on the part of the legal system and the parties involved. The determination of tort liability in order to internalize harmful externalities is considered an extension of Pigovian taxation. The theory of Pigovian taxation, named after economist Arthur Pigou, suggests levying taxes on goods or activities that generate negative externalities such as pollution or congestion. Now, these taxes aim to internalize the external costs associated with these activities, thus aligning private behavior with social welfare. Hence, the economic analysis of law views tort law as a mechanism for regulating safety in the context of broader goal of efficient allocation of social resources. Judge Learned Hand introduced a pioneering mathematical model of negligence in the landmark case of US versus Carroll Towing Corporation. His renowned test for negligence posits that an individual or entity is considered negligent if the cost of taking precautionary measures B is less than the probability of an accident P multiplied by the resulting damage L. Therefore, B is less than P into L. Herein, the product of P and L must be interpreted as the expected marginal reduction in accident cost, and B must be interpreted as the marginal cost of care or precaution. As discussed, the rule of liability under tort law requires the plaintiff to prove harm, causation, and fault. The law of torts determines fault by ascertaining whether the conduct of the injurer was negligent or intentional. Furthermore, the negligence may not be binary and easily affects to the injurer. It may also take within its ambit the victim, as in the case of contributory negligence. Being found liable in torts typically involves engaging in actions that entail unreasonable risk, which in turn stem from not taking precautions that are justified by their cost. Consequently, being at fault in torts essentially equates to behaving in an economically inefficient manner. Therefore, we can define negligence as the failure to allocate resources optimally towards ensuring safety. An economic perspective defines fault as the inability to exercise reasonable care or take necessary precautions to prevent foreseeable harm. This failure to act prudently may lead to legal liability and the obligation to compensate the injured party for the damages suffered. In essence, fault in tort law can be viewed as a deviation from economically efficient behavior where individuals or entities fail to internalize the full costs of their actions, thus resulting in negative externalities for others. However, the economic representation of fault is not simply about assigning blame for the harm done. As a concept, it focuses on how legal system uses financial consequences to achieve deterrence and incentivize precaution. Herein, we can take a look at two aspects: the economic determination of the damages and the economic determination of precaution. The economic determination of damages help us identify the potential cost that a person may incur as a result of their fault. A comparative analysis of the two elements allow us to incentivize efficient precaution. To achieve this objective, the legal system must ensure that the damages are greater than the economic cost of precaution. This makes the debate a question of costs and benefits. Now, how to estimate the damages? When a person suffers any injury, tort law recognizes a wide variety of losses such as economic losses, medical cost, reduced earning capacity, etc., and non-economic losses such as suffering, mental and emotional distress, etc. An economic inquiry into the damages suffered by a victim requires an estimation of the pain and suffering of the victim. In Botha versus Berner, 1958, the court stated, for hundreds of years, the measures of damages for pain and suffering following in the wake of a personal injury has been fair and reasonable compensation. This general standard was adopted because of the universal acknowledgement that a more specific or definitive one is impossible. There is and there can be no fixed basis, table, standard or mathematical rule that will serve as an accurate index and guide to the establishment of damage awards for personal injuries. This general standard of determining fair and reasonable compensation has been a matter of historical difficulty which ranges from monetizing the non-economic losses to determining the variables that are to be considered and what can actually be termed a loss for victim. The economic or monetary loss is easy to determine in terms of the actual cost incurred by the victim, but the non-economic or hedonic losses are the ones that are difficult to determine. There doesn't seem to be a common standard for determining these losses, but we can examine some models like the following. First is the golden rule. This approach solicits a valuation from the tort juries for asking them to place themselves in the shoes of the plaintiff when determining damages. The courts have rejected this approach due to their desire for fair and impartial jurors free from any biases. There are different variations for this rule. For example, asking the jurors to estimate how much the plaintiff would be willing to accept to bear the risk of the injury. These variations have varying success rates. Second is per diem. This approach involves calculating compensation for losses based on a daily rate. This method assigns a specific monetary value for each day that the plaintiff suffers harm or loss due to the defendant's actions. Cases where the harm is ongoing or where it is challenging to precisely quantify the total extent of damages often employ this method. The per diem approach aims to provide a fair and reasonable estimate for the plaintiff's losses by considering factors such as pain and suffering, loss of earnings, medical expenses, and other relevant costs incurred on a daily basis. Third, being medical cost. This approach uses the medical cost as a starting point for the determination of damages and applies a variable multiplier to estimate the cost of pain and suffering. The juror retains discretion over the multiplier, but this has limited application as in every case there might not be medical cost involved. Other factors like loss of pleasure of life scale, quality adjusted life years, fixed amounts in cases of mass tragedies, etc. are also utilized in determining the damages. Usually, multiple measures are used in order to estimate the loss incurred by the victim. One crucial element to consider is the case of contributory negligence. In such cases, it is considered that both the injurer and victim are at fault, and the action or omission of both parties resulted in the tort. Determining damages in such situations necessitates a careful balancing act, as the determination applies not only to one party but to both. In the context of economic losses, we can consider the losses incurred by both parties, determining whether one party incurred more than the other and whether the other should compensate. Factors such as differences in the ability to pay, monetary standing, and income of the parties are all relevant consideration. But the problem arises in the context of non-economic losses. Due to the subjective nature of these damages and the difficulty in figuring out the level of fault and how it affects the plaintiff's well-being, estimating non-economic losses in cases of contributory negligence in tort law is very hard. Contributory negligence occurs when the plaintiff's own actions contribute to their injury or damages, reducing the defendant's liability. In such cases, determining the appropriate compensation for non-economic losses becomes particularly intricate due to several difficulties. Let us now understand about the efficient precaution. The core objective behind legal rules for assigning liability is to minimize the total cost associated with risky activities. The basic model for achieving the same is called the model of precaution. Primarily, there are two models of precaution, the unilateral model and the bilateral model. The unilateral model discusses how only the injurer can invest in precaution or care to reduce the livelihood and severity of the damages borne by the victims. For example, the injurer can invest in taking due care to reduce the probability of an accident and the damages suffered by the victim. In bilateral model, we can investigate how both the injurer and victim can invest in precaution. For example, consumers can invest in terms of following the manufacturer's safety instructions, and the manufacturer or potential injurer can invest in making the safety instructions visible and taking measures like decreasing the size of the opening of the bottle to regulate the quantity of the product being used to ensure that safety protocols are followed. In cases of no liability, when the injurer faces no liability, the victim's damages are external to the injurer, so he will simply minimize his expenditure on precaution. This situation remains the same in the context of both models. In the bilateral model, when there is no liability on the part of the injurer, the victim will have to invest in optimal care and bear the full cost of the damages. Therefore, in the bilateral model, no liability for the injurer results in strict liability for the victim. In cases of strict liability, when liability is imposed according to the rule of strict liability, the injurer is liable for the victim's full cost. In the unilateral model, the injurer is required to invest and exercise due care to prevent the victim from bearing the full cost of damages. Under the bilateral model, the injurer faces full liability for the victim's damages and therefore chooses optimal care. On the other hand, the victim receives complete compensation for her losses, thereby absolving her of any liability. They therefore choose zero precaution. Thus, strict liability for the injurer is equivalent to the no liability for the victim. As we can see, the bilateral model, neither strict liability nor no liability leads to an efficient outcome. This is because neither party takes full responsibility for the damages. In order to have the proper incentives, both parties must face full responsibilities for the damages at the margin. That is, parties must face responsibility to the extent of their contribution resulting in damages. For example, in a situation where a person is speeding on a road and a pedestrian, instead of walking on the sidewalk, is walking on the road, both are responsible for or contributing to the accident. Therefore, both should be liable only to the extent of their contribution. This investment in precaution leads to diminishing marginal returns. As a result, the injurer, or in the context of the bilateral model, both the injurer and the victim are bound to invest in the most efficient precaution first. Affixing liability in terms of cost to the victim or the injurer incentivizes them to invest in efficient precaution. For the injured person, this could involve investing in taking due care and adhering to a reasonable standard of care. Ensuring efficient precaution aims to decrease the livelihood and severity of accidents, a concept also known as the deterrent nature of tort law. Now, concluding with today's module, although the economic analysis of tort law appears important in the context of moral philosophy, it has its drawbacks. John Finnis had argued that by applying economic analysis to tort law, which deals with accidents and harm, the focus on a singular metric may inadvertently obscure a crucial moral contrast, the differentiation between intentional harm and unintended accidents. But on a moral footing, as a counter-argument, it is also stated that efficiency in tort law is aimed at minimizing social cost and maximizing social welfare. This is achieved by providing incentives to both the injurer and the victim to take efficient precautions. The economic representation of fault within tort law adds a vital layer to the traditional blame-based approach in our legal system. By considering the financial consequences of accidents or torts at large, tort law can influence behavior and even promote societal well-being. However, achieving this balance requires careful consideration of damage valuation and efficient precautionary models. By understanding the economic motivations behind behaviors, lawmakers can create effective regulations and incentives that promote socially desirable outcomes. For example, congestion pricing on toll roads can nudge citizens towards carpooling or utilizing public transport, reducing traffic and its associated cost. Economic analysis also helps identify behaviors with negative externalities, allowing laws to be structured to internalize those costs and discourage harmful activities. In essence, economic analysis in law is not just about numbers. It's about understanding human behavior to design legal framework that promote responsible conduct, minimize societal cost, and ultimately create a safer and more prosperous society. With this, we come to the end of this module. I hope you were able to gain a better understanding of the economic representation of fault and efficient precaution. Thank you and happy learning.